So, when you're dividing assets in a high net worth divorce versus a regular divorce, there's some differences that come into play. A lot of times in high net worth divorces, you have people who own a business, and we have to get a business evaluation done. That has to be done usually through a CPA. That's one thing that we look at. And then also, we have to look at, are there any trust involved in that high net worth divorce, and how we need to go about dividing those trusts as well. So, in a high net worth divorce case, the assets get divided in the same manner as any other case. It's an equitable division. The judge is going to try to get it a lot of times as close to 50-50 as they can. That doesn't always happen, but that's why it's really important that we have the correct values of the assets to present that to the judge and to the court. Some challenges we might see in splitting assets in a high net worth divorce case is some of the assets may not be as easily to divide. Such, for example, if we have a business, it's kind of hard to divide a business. So we've got to get a valuation of that business and figure out how to pay the other spouse their portion of the share of that business. So to evaluate a business, we always reach out. We have different CPAs that we work with in the area, and we reach out to them. They will then kind of guide us for each type of business, what documents they're looking for, financial information. And so we, along with our client, work with getting that information to the business evaluator. And then sometimes too, we may have two different business evaluators, and they may come up with different values of a business. And so then we've got to take depositions and get through that discovery process to see how each evaluator came up with the value of the business. So in a high net worth divorce, alimony could still be an issue, but a lot of times the spouse who is economically disadvantaged may be receiving so much assets in the divorce that alimony may not really be as much of a need as it would be in a different type of divorce. So there's not necessarily caps that can be awarded as to the amount of alimony. The court's going to really be looking at what standard of living has this person established, and should that standard continue, or can it continue based on the other person's ability to pay. So prenups are becoming more common, and if they are properly executed, yes, they can work. Two of the main things you need to remember is that you have an attorney draft the prenuptial agreement, and the other thing to remember is that both people have their own independent attorney, and that needs to be reflected into the agreement, because what we're trying to make sure is that the person coming into the marriage with not as many assets as the other person, that they're aware of what they're doing, and that they're aware of their legal rights. And we also want to make sure it's not done in what I call a shotgun manner, so as we're not doing it 12 hours before the marriage ceremonies to take place. We want to make sure that both parties have ample time to review the agreement and to understand the agreement. So if you have a high net worth estate and you're considering getting divorced, there's certain implications that you may need to consider, such as valuing businesses and other assets. If that's a situation that you're facing, please feel free to reach out and contact us at Mandy Hancock Law. We will be glad to schedule a consultation and help navigate you through the process.